Okay, this is the 100-120 class. This is just some practice. There's some bills that are in the assembly right now. Go ahead and read the introduction. For the record, this report marks the beginning of a new 2-year session in the California legislature. Any bill that was not passed and signed by the governor as of September 30th of last year is dead, and the legislature has started with a clean slate with new bills introduced in each house between December 5th and February 17th of this year. So in keeping with that schedule, your Caldra Board of Directors and Legislative Committee have been very busy as we've reviewed the language of these new bills to be certain that we find every piece of legislation that could potentially impact you, our members, and the reporting profession. So far, we have identified 9 bills that contain language that might either benefit or harm reporters, and we are closely following these bills and will continue to do so, and also watchful for any amendments that may later have some effect on us. The status of each Assembly and Senate bill below was current as of April 27th. We will, as always, keep you updated on these in each issue of the Deposition Reporter, as well as in our e-notes when any important developments occur. So please continue watching and listening for our legislative reports. AB 96, Ting, summary, called the Budget Act of 2017 as the name reflects. It would appropriate funds for the support of the state government for 2017-2018. We'll be following this because it includes budgeting for the courts and so could have some effect on jobs for officials throughout the state. Referred to as the Assembly Budget Committee, no hearing date set yet. AB 701 Gallagher. Existing law requires that a hearing impaired participant in a civil or criminal proceeding, including arbitrations, mediations, and administrative hearings, be provided with an assistive listening system or a CAT system upon request. As amended March 30th, this bill would change the term hearing impaired to deaf or hard of hearing, would append the language, the services of an operator of a to CAT system, and would define CAT system as one that provides real-time captioning or similar technology, would require that advance notice of the need for the services of this operator be given when the hearing is set, or not later than 5 days prior to the hearing, that the hearing will not begin until the requested system is in place or the services can be performed. It would also require that the Court Reporters Board establish standards to certify operators of CAT systems as defined above by January 1, 2019, and that by July 1, 2019, operators of so defined CAT systems shall be certified pursuant to the standards so established by the CRB. The bill would also prohibit the official or pro tem reporter assigned by the court to produce the official record from being the operator of a CAT system as defined. The operator of a CAT system shall provide the speech-to-text equipment to be used unless otherwise supported by the court. Support or opposition with CCRA as a sponsor, Los Angeles County Court Reporters Association, Northern California Court Reporters Association, and Sacramento Official Court Reporters Association. No opposition on file. On 3/29, it was heard by and passed as amended by the Assembly Judiciary Committee. On 4/26, it was heard by the Assembly Appropriations Committee, referred to the suspense file. All right, this is some congressional warm-up for the record. Mr. President, we see from this job description that the Joint Chiefs, and particularly the chairman, have the responsibility for preparing all of the plans and providing the readiness necessary for the defense of this nation. And if the plans for our defense are not adequate, there is nowhere else to look for assigning responsibility for our not having it. If the plans are not fulfilled by their superiors, I do not see how the Joint Chiefs can say, well, we will go along with the political figures in the administration and keep quiet. As for the role of the chairman of the Joint Chiefs in that job description I just cited, it is as follows. The chairman of the Joint Chiefs of Staff, while holding such office, takes precedence over all other officers of the armed services. Besides participating as a member, the chairman serves as presiding officer of the Joint Chiefs of Staff, provides agenda for their meetings, and works to ensure that business is carried out as promptly as is practicable. He informs the Secretary of Defense on issues before the Joint Chiefs of Staff, including those upon which agreement among the Joint Chiefs of Staff has not been reached. The chairman manages the Joint Staff through its director in consultation with the Chiefs of Staff and with the approval of the Secretary of Defense. He selects the Director, Joint Staff. The appointment of officers to serve on the Joint Staff is subject to his approval. Mr. President, I read all of that into the record for one purpose: to demonstrate that the chairman of the Joint Chiefs of Staff is the one person in charge of all planning. He takes precedence over all other officers of the armed services. It is his job to see that the business of the Joint Chiefs is carried out. The advice rendered to the Secretary of Defense and the President is inadequate to the task at hand. The responsibility for that failure can rest nowhere except upon his shoulders. So if the chairman of the Joint Chiefs now comes before the Armed Services Committee seeking confirmation for a second term and says that we are on the edge of strategic inferiority, the responsibility for that grave decline rests squarely on his shoulders. If his counsel could not arrest that decline by convincing his superiors to avert that danger, then in my judgment, he should have done precisely what he said in my office 2 years ago. He should have resigned, but he did not resign, and he is seeking reconfirmation. If any senator infers from my remarks that I am suggesting that General Jones should be insubordinate to his superiors, or that he should go over the heads of his superiors to Congress or to the people, or that he should try to deceive his superiors by failing to carry out their orders, then let me disabuse that notion. As long as he is the first-ranking military officer in the nation, his duty is, in fact, to obey. But it is his higher duty to resign if he cannot conscientiously carry out his orders and keep his oath to defend the Constitution. But instead, General Jones became the defender of the strategic decline which he now admits. I cannot conceive of a military advisor giving advice that leads to strategic decline. We must assume that he did not advise a decline, but the decline was programmed by the administration anyway. We must assume that the decline was the result of political decisions. The general, therefore, became the defender of those political decisions by presenting military rationalizations for them, even though he knew that those political decisions were leading to decline. The pro-defense rhetoric of the present administration is fundamentally deceptive. American military power has eroded during the Carter administration to a point at which the national security of the United States is in clear jeopardy. Now even the chairman of the Joint Chiefs say we are on the edge of inferiority. Okay, this is some jury charge material for the record. This is the vehicle that brings the defendant into court, and it is not proof, it is an allegation. The proof, as I say, must come from the witnesses who have taken their oaths and testified. Now, I charge you that an assault is an unlawful attempt coupled with a present ability to commit violent injury upon the person of another. Therefore, an assault is any unlawful attempt or offer with force or violence to do bodily injury to another person where they have the ability to complete that attempt. Now, members of the jury, A battery is the carrying into effect or the successful accomplishment of the assault by using or applying force to the person of another, however slight, in a rude, angry, or resentful manner. Now, there are two kinds of assault and battery that you should be concerned with, because this indictment charges this defendant did commit assault and battery with intent to kill. Also included in that is the lesser offense of assault and battery of a high and aggravated nature. Now, that is by law included within this indictment, even though it is not specifically written in it. The greater includes the lesser. An assault and battery with intent to kill is such an assault and battery which, if the person assaulted had died, the party making the assault would have been guilty of murder. Now, in order for you to fully understand what an assault and battery with intent to kill is, it is necessary for me to charge you, to a limited extent, the law of murder. Now, murder is the killing of a human being with malice aforethought, either express or implied. Now, there must be malice, or there can be no murder. Likewise, an assault and battery with intent to kill, the element of malice must be present. Now, malice is any formed design or doing mischief, whether it arises from hatred, ill will, or otherwise. Malice aforethought means that the malice must have been in the mind of the party at the time the blow or blows were struck. Malice need not be in the mind of a party who struck the blow or blows for an appreciable length of time prior to inflicting the injury. If it was in the mind just before the blow or blows were struck, and at the time the blow or blows were struck under the law, that is malice aforethought. Now, malice aforethought is divided into two kinds, express malice and implied malice. It makes no difference whether the malice was express or implied, so long as one or the other is present at the time. Now, express malice is when a person, by word of mouth, expresses his hatred or ill will for another, or where the state shows that he made preparation before the blow or blows were ever struck to do the deed which was accomplished, lying in wait for a person or any acts of preparation going to show that the deed was in the mind of the accused would be express malice. Now, implied malice. The law implies malice where the deed is done with a deadly weapon, such as a knife, pistol, or dagger, or such weapon of that nature which, when used with intent to injure a party, is calculated to produce death or serious bodily harm. If the state proves that the deed was done with a deadly weapon, the jury may find malice from this fact alone.